Good morning and welcome. This is a brand new week. I'm Ayo Makinde.
Absolutely beautiful Monday morning here in Lagos, Nigeria's commercial capital. You're welcome to Sunrise Daily. I'm Kayode Okikyolu.
Well, it seems like you're always looking for more trouble with that.
Yeah. No, but it's the truth. The truth is the truth, absolutely. And I mean, we're at a time where there's the different angles of the truth. I mean, the different narratives being put out. You wonder, I mean, people have agenda here and there. And as, newsmen, that's the first thing we do, try to look at the different angles, see where this tilts to.
One of the things that he will tell you in the media, in training, is there is fact, there is truth.
And alt-truth came. But, what we're driving at this morning is trying to get to the truth of this matter. I mean, when you get to the bottom of an issue, get to the truth. And we're referring to this video that surfaced a few days ago of now former governor of Anambra State, Willie Obiano. The video showed him sitting on a chair. There was another person right beside him. He was taking water from a plastic container, and he was dressed in, I think, a T-shirt and shorts. And someone was recording him, apparently from behind a desk that looked like an office desk or something. And, he had a tag, Governor of Anambra State, on that video. And that has raised a lot of questions. There are three possibilities with that question. One, maybe he was recorded or done when he was still governor of the state, who knows where. Maybe it was done in EFCC custody, the first time out, where it was said to have been, is it invited? Or it was done at this time when he was just arrested by the EFCC. But, the two options leaves lots to be desired, because you wonder if definitely that's not standard practice. You wonder how things should be conducted, especially within the custody of the EFCC. And now there are questions being raised, especially to the EFCC, asking what exactly happened. Was this shot right in the EFCC custody? If it was, who was it? Who shot that video? Who shot that video and put it out into the public domain? What is that meant to achieve? Is this a process in trying to get justice, or trying to, do the investigation or the questioning? Lots of questions, because you see that. That was sort of a vulnerable moment, it would seem. So there are questions as to why or how this came about. And I think the onus lies on the EFCC, who's been mentioned in this case time and again, to come out and say, well, this was not done in our custody. This definitely is not us. This is not standard practice. Or to come and say, well, yes, perhaps someone drops the ball and this is what we're doing about it. Because it's important to follow the due process in whatever is going on, such that we can eventually say, yes, justice has been served. Not justice just served, justice seen to be served. So a lot of questions, majorly for the EFCC to answer this morning.
Those questions are not just going to go away. We can't wish them away. There are questions that need to be answered, because there are questions people are asking. One of the first questions that I asked myself was, wait a minute, what's the process of engaging anyone, whether you are arrested or invited? I think there are two different things there. Is it an arrest or is it an invitation? Well, the media reports say it's an arrest, but exactly what is it? And then was that the process? Okay, and it would seem like that video was covertly recorded. So then, what's the objective of it being recorded? Sent to whom? For what reason? And all those questions. Is it to witch hunt? Is it to embarrass? Is it to, what exactly are the objectives, and why was it? Because it wasn't like a media coverage or anything. So those questions will definitely be there for one to ask. I don't think it is a good thing to embarrass people for whatever reason. There is a standard to our laws in this nation. You are innocent until proven guilty. What's the objective of that clip made viral? The onus is now on the EFCC to say, yes, it was in our custody. No, it wasn't from our custody. Marka, good morning.
Good morning, gentlemen, and shall I say a productive week to all of us. That's wishing all of us a productive week. The video going round, did I make anything of it? Yes and no. Yes, in the sense that it's not proper. I don't think that sort of thing is proper. as you gentlemen have pointed out, is that part of the procedure? And, you know, should people be sanctioned for? I think that, you know, if it's the EFCC, which I strongly suspect that it is, I think that, you know, they need to conduct an in-house investigation to find out what is going on. I mean, who would do that? Why do you want to do that? Was that in response to questions being asked? Because sometimes, you know, we journalists, we insist on having our sources. There are times when, you know, there are questions raised. I know that shortly after he was arrested at the Lagos International Airport, Murtala Mohammed International Airport, there were questions as to whether or not, because a story made the rounds the following morning that he had been released and was on his way home. Much later, we got another response from the EFCC saying, no, he hasn't been released, he's still very much in our custody. So was that video supposed to be proof of still being in our custody? I mean, we're talking about, sometimes we talk about proof of life video. But I do not know if that was what it was meant to do. Maybe someone was asking for evidence and maybe the person thought, okay, this could be some way to show you evidence. Or maybe the person was just, you know, just trying to show that, you know, nothing lasts forever. I do not know what the motive is. But for me, that is like the list of I think that's a list of our issues as a people, even though it all speaks to parts of the issues that we're all currently dealing with. You know, the anyhowness that sometimes goes with, you know, with being in Nigeria. Somebody has been arrested, a person is facing processes. Can the person face the process according to the laws and not be according to the laws of the land? I mean, and let's leave it at that. That will be my final take on it, gentlemen.
Well, that's one way to look at it, and most certainly the way I would go with as well. But what then do we say of this 14-year-old that was, that according to that statement from the fan, was ripped off?
Yeah. So a little background here, because a lot of the things, you know, start off on social media, and then, I mean, if you're on social media, if you've been on Twitter for a while, you may have come across that particular story. So a Twitter user on February the 19th, I think there was a conversation around, you know, airport conduct and all that. So this user, Ratchet Rain, tweeted and said that my 14-year-old daughter, 14, is traveling by herself. Immigration took all her money before they let her go. They took money from a 14-year-old, didn't even hear, or rather leave her with 1 kobo or 1,000 naira so she can buy food while she waits. And she tweeted saying, how wicked, and mentioned FAN, that's the Federal Airports Authority of Nigeria. So that was on February the 19th, and as you'll expect, there was a lot of response. Shock first, saying, 14-year-old? I mean, how bad can it get? How extreme can you go to extort a 14-year-old? And I'm talking all the money from that 14-year-old. And there was a lot of pressure saying, no, this must stop. And this is coming off the series of complaints from people using the airport saying, I get into the airport and I'm scared because this person is asking you for either dollars or pounds or whatever, or even naira, whatever you're coming with. Another person is asking you, imagine having to go through different officials and you have to just, oil the palms. It's unthinkable, especially if you've been to other airports in the world. So a lot of people had been complaining. In fact, we had a foreigner coming to Nigeria and complain, do a video about that. There was some response, but apparently these things are still going on. So eventually, we saw the Federal Airports Authority of Nigeria respond about a month after, just this past week, saying with respect to that case of a 14-year-old being extorted, that they actually checked CCTV footage. And I was grateful for CCTV footage, really, because a lot of times you wonder, do these things work? But apparently, it was working in the airport, and they reviewed and said 2 officers were found wanting. And, you know, this anyhowness that Mampwe talked about, it's important to have, you know, do I say repercussions? There should be some sort of punitive measures following if we really need to cleanse the system. So thankfully, FAN said that consequently, the officers were made to refund the exact amount collected from the 14-year-old passenger. Their on-duty cards were withdrawn permanently, and they have been banned from working in any Nigerian airport. And Mampwe, I know you hearing this was a shocker for you as well. But do you think this is enough closure, especially to end all of the anyhowness we're seeing now?
Certainly not, Coyote. I only just got to hear that story and I didn't even know how to react. Because I remember my first time alone traveling out of the country. Imagine, I mean, at least by that time I was wise enough. You know, I'd gained some wisdom and I had a lot of tips from my aunties. I'd gone through university before I traveled out alone by myself. But I'm trying to imagine a 14-year-old. When I was 14, I was in SS1. Senior Secondary School 1, and I was pretty naive and pretty vulnerable, and I wouldn't have known what to make of the system. Now, going through immigration, something as scary as immigration by myself, I don't know. And then the little money I had, I think all the money came up to 8,000 naira, which the mother spoke of, as she had on her, possibly just to buy something while she waits at the airport till you're bored. By the time you arrive, obviously family might be waiting to look after her, and you know, that should be that. And all of this money is extorted from her. Maybe it's even through, oh, a fine girl, you know, how are you doing? Where are you going to? You know, anything for uncle. It could be something as silly as that. And the poor little girl maybe haven't heard stories, would just naively, or maybe she's just a generous-hearted person, give all that she has. I'm really pained this morning, to be very honest. I'm embarrassed. I'm ashamed of us. I'm ashamed, you know, of our officers. And I do not think that the punishment which they have been subjected to, just taking away their on-duty cards, is sufficient. Because what they did was traumatize that little girl. What it did was introduce her to a Nigeria which she must have heard of. You know, they reaffirmed, you know, the story that we're not very good people. And this is going to live in that girl's, excuse me, that young girl's mind. It's a story she's going to recount to her children. And don't forget that she was actually leaving the country. I don't know for what purpose, maybe for educational reasons or maybe a holiday. It could be anything. I mean, that's really none of the issue. But she most likely will be introduced to better. If she tells that kind of story outside of this country, it's not a story that will portray us well. When we see people who are vulnerable, children, people who are not well, people who are elderly, I think that at some point, you know, a part of us, which might not be usual, you know, should step out. I do not think that it was just right to return, because from what we read, the exact amount, Fan said the exact amount was returned. When an injury happens, and I consider this a grievous injury, not just to the girl and her mom, but to all of us, it's an embarrassment. You don't just return what it is that you are perceived to have, you know, what is perceived that you have, you know, stolen. You return a figure far higher as compensation, because what you have done is injure the little girl. You've traumatized her. And you've traumatized the mother. I'm sure she's there wondering, but I gave you some money. Maybe the girl called and said, I'm hungry, mommy, and I don't know how much longer this flight we have to wait. The mother says, okay, buy something. I'm just painting a scenario. Buy something while you wait now, and I don't have any money on me. All the money I had, I gave it to immigration. How is a mother supposed to process that? And she knows she cannot reach her daughter anymore. How? And some people are cool with it. It's okay. I'm glad that FAN and immigration took pains to investigate. But I'll say again that that certainly was not sufficient compensation. And I do not think that what those officers, or the punishment that has been meted out to those officers, was sufficient enough. There needs to be a little more. What it is, I don't know, but we're asking for a little more. Gentlemen.
Well, let me quote the Vice President. It is very important that we show respect for our citizens and show them that we are concerned about them, that we are not just a regulatory body that feels that its role is just to be a policeman. That's the Vice President of the Federal Republic of Nigeria on government agencies. Let's hope that, as Marco said, more will be done. Let's switch to the papers now, begin with the Nigerian Tribune, and it leads with politics, of course. Almost all of them are talking politics this morning. PDP presidential ticket. Governors Atiku draw battle line. Saraki, Tambuwal, Bala opt for consensus. And the story is on page 2. There's a rider, ex-vice president declares Wednesday Find the details on the inside pages.
Almost sound like say Governor's Atiku throwback.
Well, it's a headline. So if
Governor's Atiku.
if you want more, go on the inside pages.
Right.
Yeah. And under that picture on the front page would be like, well, let's balance it. There's the APC story as well. APC convention, governors, senators split over chairman, youth leader. See, governors again. The story is on page 3 of the paper, has a number of riders. Flood displaces 7 communities in Niger, and several other stories you'll find interesting on the front page of the Nigerian Tribune today.
Take a look at Daily Trust next, a spot for choice for a moment. And this is what you have on the front page of the Daily Trust politics as well. It's the season, right? APC convention, stakeholders perfect consensus list as aspirants intensify lobby. So, I mean, how many days now to the APC convention? About 5 days to that planned convention on March the 26th. And as you would expect, the plot is thickening. So that's the lead for the Daily Trust. But there are other stories on the front page of that paper. You see 2023 presidency, Saraki, Tambuwal, Bala Mohammed agree on consensus. So it looks like consensus is the order of the day. But take a look at this one from Zamfara. It's on security. Zamfara hires ex-servicemen as bandits displace over 700,000 persons. So talk about getting them back into the fray just to give what they can, but just shows a bigger concern. And I mean, this is worth making headlines any day. Let's leave it there for the Daily Trust. Mark.
Let's take a look at the Abuja Inquirer for you, and they have this National Convention, APC faces fresh hurdles. Electoral Act demands membership register. Act not retroactive, that's according to the party chieftain. You find all the details on page 3. And you also see this here, measles outbreak hits Benue IDP camps. Page 12 is also there. It's also on page 12. You also find on top of the name plate, VIO shun public outcry to crush another 1,500 motorcycles. It's on page 3. Mindless waste, that's according to residents. You have a number of other stories at the bottom. But for those who are wondering what is going on with the NYSC call-up letter, look at this. NYSC call-up hold institutions responsible. That's according to JAMB. Let's leave it there for the Abuja Inquirer.
And switch to Nigerian News Direct, which talks about power outage. FG to restore electricity nationwide today.
And
I thought you weren't going to say anything.
you know, sometimes you go through these things and the best you can do is laugh or make a joke about it because...
Okay.
There you go.
Well, there are a couple of riders. Gas shortage responsible for power outage. That's according to expert. Well, that's also what I think the minister said last week. Serap charges FG to probe missing 11 trillion naira electricity fund. No, it can't be missing. I mean, hey, it can't. 11 trillion. It can't be missing.
Are you a witness to it?
No, come on, it can't be
it's
missing.
not missing, right?
Okay.
Sarah,
It can't be missing.
You know who to ask now.
It can't, 11 trillion naira, come on.
I mean, it just shows that we've sunk so much into that sector. And we literally have not much to show for it.
It can't be missing. 11 trillion naira. Wow. No, it can't be missing.
Well, next up is Daily Times. The Daily Times is what we have for you next. And it talks about the fuel crisis. And you see, fuel crisis, APC kneeling on the necks of Nigerians. And that statement's come from the PDP, and I think that's just meant to paint the picture of one of the incidents that happened in the United States with police violence and all. Says there is limits to what people can bear under an administration that is insensitive to their plight. So that's a major one. And I saw on one of the dailies that, you know, fuel queues are still around anyway. I was at the filling station recently and they said, you know, we're not selling at all. And that's a filling station you'd see selling petrol on a normal day. On top of the nameplate, you see Buhari condemns violence in Southeast. Consoles Obiozor says security situation undergoing review. Markwe.
The Guardian is the next one here, and they have this: stakeholders on workable option as MPC meets today. That's the Guardian newspapers Deliberate on 18-month-old policy rate today. Ex-committee member Ekbo calls for rate hike. Market doesn't relate with NPR rituals anymore, says Owo. Use trade policies, other fiscal incentives to drive growth. We need National Economic Summit, not MPC, to fix Nigeria, says Onyekbere. It's on page 2 of the paper. You also have a number of stories on the front page. APC chair race narrows to Adamu Akume Almakura Musa after Sheriff's exit. You also see this. Reps summon 17 subsidiaries of defunct NNPC. Is it really defunct? Well, you find details on page 6 of the paper. And this one from Lagos. Lagos overwhelmed as beggars take over strategic parks, roundabouts. That's also on the front page of the paper. Let's leave it there for The Guardian.
Let's just hope that government knows what to do. Daily Independent has this one, also interested in energy. Weak oil production subsidies may erode gains of rising prices. That's the lead of the Daily Independent newspaper this morning. And the story continues on the inside pages. Right under the picture on the front page, anti-Buni governors plan to revolt against Buhari at APC convention. When I see some word revolt at convention, well, anyway, let me just take his political gunshot. Is that okay? The writer says no cause for alarm, says presidency. Find the details on the inside pages. Discordant tunes trail airlines attempt to import aviation fuel. Find the details on the front page. Continues on the inside pages of the paper today.
Take a look at New Telegraph. I'm already in the inside pages of that one, but the front page has this one. Energy crisis, CBN earmarks 104 billion naira to stabilize electricity supply. So I think this just tries to paint or stretch that story about, returning electricity supply and all of that. You see, lack of PPAs, serious threat to Nigeria's power market. That's coming from Gencos. Debunk claims of keeping country in darkness over 1.6 trillion naira debt. And you wonder, what does PPA mean? I mean, to a core member, that will mean one thing, in primary place of assignment. But in the power sector, it means, I think, the power purchase agreement. So that just clears the air, so we know what we're talking about here. And you see, coming from PDP, Buhari abdicated his duties. Let me just show you this one, coming from the police. Police to officers, do not demand customs papers from drivers. Say tinted glass permit issuance remains suspended. So I wonder if this has trickled down to the men on the roads. And finally, ASU to students. So this is the, 6th week of ASU strike. Join our struggle if you want strike suspended. Varsity Dawn gives stranded Unimate students 1 million naira for transport fare. It's just sad that this is going on, and it looks like the people concerned are carrying on as though it is normal. It is
scary. It is scary. It is scary. Because I always look forward. Another 10 years, 20 years from now, when I look at all these issues, we haven't still recovered from the brain drain of the 80s.
And here we are again.
Literally planning for another one.
That's a New Telegraph this morning.
Okay, so we have Vanguard, energy crisis, 600 naira per litre, kerosene hits nation's poor. That's on the front page. Darkness persists as power generation remains low at 2,312 megawatts. Only 13 of 20 plants generating power to national grid at below capacity. APGC blames NBET. Federal government threatens to sanction depot owners selling above approved price. So that is on the front page. You also have this APC convention, stakeholders in last-minute consultations for unity list. And there's the other side to that slap story. Inauguration day slap, Bianca's attack shocked me. That's from Ebele Obiano. So that is also on the front page. They have a number of stories for you on politics, which I'll leave you to do yourself. If you flip to the back, you also have sports here. Eguavon alters Super Eagles squad as Bonki replaced Ndidi. So for that particular clash, Ghana versus Nigeria, you might want to flip to the back page to see just how we're getting set. Let's leave it there for the Vanguard.
Leadership newspaper has this one. 2023 presidency. Amid southern agitation, Tambuwal Mohammed Saraki opt for consensus. That's the lead of the paper, to make position known soon. Atiku declares on Wednesday. That's the lead of the paper. Right under the picture, right under the nameplate, COVID-19 interventions. CBN extends 5% interest by 1 year. And then there is this one. 2023 election will determine future of Nigeria, ascribed to former Governor Obi of Anambra State. That's the leadership newspaper this morning, and that's the much of the papers we can take. We're back after now. We'll take on the issues for the day. Please stay with us.
Our client approached the Federal High Court to determine whether Section 84, subsection 12, when read together with Sections 66, 107, 137, 182 of the Constitution is not inconsistent. Now, the court agreed with our submissions, and it has just ordered that Section 84, subsection 12 of the Electoral Act is inconsistent with the rights of Nigerian citizens when read with Section 66 of the Constitution, 107, 137, 182, and now nullified Section 84, subsection 12 of the Electoral Act. And as equally has ordered the Attorney General of the Federation to delete Section 84, subsection 12 of the Electoral Act forthwith. Now, the implication of this is that it has provided a congenial atmosphere for politicking and political space for 2023.
The interpretation of Section 84.12, which the court has graciously put to rest now, as being a total nullity, being in conflict with the provisions of the Constitution. And originally, we honestly believed that it was inadvertence on the part of the National Assembly. It was a big error. And being gentlemen and distinguished senators and the members of the House, I think they will now go back and do the right thing, since the court has made pronouncement on it. And that put to rest every other issue with regards to that, so that we can move on with the national issues that are besieging us as a country and as a nation. So we don't have to be bogged down on the needless technicalities.
Let's help you make sense of some of the issues that have been raised over time by that provision. Professor Paul Anambra joins us this morning virtually from Lagos. He is a senior advocate of Nigeria, as well as Sebastian Horn, also a constitutional lawyer and senior advocate of Nigeria. Gentlemen, thank you for joining us this morning. Let me begin with you, Prof. Many people are asking all kinds of questions. And for those who are unschooled about the law, so many sections are being thrown for and against. Help us make sense of it. What exactly is the issue here?
Well, we begin from where I think I understand it. The Section 6 of the Constitution empowers the judiciary to interpret laws. And by that Section 6, to avoid use of force, if you are unhappy with the legislation, you approach the courts. I guess that's what happened here. However, the court, let me make a point also here that this is not a case of a bill. It has become an act of parliament. So a court, Federal High Court, has powers to determine whether a law validly made by the National Assembly is inconsistent with the Constitution by virtue of Section 113 of the Constitution. That having been said, if you take the decision of the court and look at it, the court is saying that Section 8412 contravenes Section 66, 1F, 107, 1F, 137, 1F, and 182, 1F. That is where the issue is. Sections 66, the sections are because it will bother Nigeria. I don't want to bother Nigerians about it. What that is saying is, if you're going to run primaries and party congresses, and you are a political appointee, you have to resign. Now the court is saying that that is inconsistent with the Constitution, which those sections 66 and all that I've just read out, those sections say, if you are in the public service of the Federation and you want to contest an election for Senate or House of Reps or House of Assembly, you need to resign 30 days before the time. So the court came to the conclusion that, okay, the Constitution only provides for 30 days, you will resign before the election itself. So Section 84 now is inconsistent. That is what the issue is.
But okay,
my position is, yeah.
Okay, go ahead.
My position is just simple. Section 66, 1F, 137, and 187 and all that talks about only limited positions of National Assembly elections. Now it talks about those in public service also. So it has no way it contravenes Section 84(12) contravenes Section 66 and all those sections that follow it. So I think that yes, the court had a right. It had made this pronouncement. It's also subject of appeal, but I don't see any contravention. I rather see that the National Assembly members who have been players in this game all this while would have found out part of the problems of our democracy and have taken steps to block it. And I foresee that that will not be the right position of the law as we climb the ladder, as parties climb the ladder of the appellate process. I think that 8412 was well made, and it should be allowed to stand. Thank you.
Okay, all right. Honorable, beg your pardon. Mr. Horn, do you agree?
Yes, I agree with him. I agree with him that Section 84, sub 12 of the Electoral Act is constitutional. And I vehemently disagree that it's unconstitutional. First of all, Section 4, subsections 1 and 2 imbues the National Assembly with constitutional powers to make legislation for the peace, order, and good government of Nigeria, in accordance with the exclusive legislative list Now, if you look at item 22 on that list, elections are included apart from local government council elections. So this piece of legislation is meant to enthrone other peace and good government of the Federation or any part of Nigeria. And if you also look at sections 66(1)(f), 102(1)(f), 137(1)(j), and 182(1)(f) of the Constitution, those limitations do not apply to the scenario here. They are talking of a person shall not be qualified to contest election. Contest election. Now, section 84(6)(2), to limit the rights of certain persons holding political offices from preparing for elections or engaging in pre-election matters. If you look at section 285, subsection 14 of the Constitution, the definition of pre-election is broadly given there. And the Constitution has said that pre-election means congresses or conventions to bring in candidates and also preparations for elections. So these are two different things. We have pre-election and post-election. Now, if you also read section 31, subsections 5 and 6 of the Electoral Act 2010 as amended, now repealed and reenacted. But even the 2022 version has just slightly amended that version of 2010. If you read those provisions and the long line of cases decided by the Supreme Court, any person who feels that a candidate has supplied a false information in an affidavit can approach the court, and the court will disqualify that person if it finds out that that candidate did that. In a long list of cases, the Supreme Court has held that this is a pre-election disputation. And if we go down memory lane, we discover that the David Leon, the then governor-elect of Bayelsa State, became disqualified by the Supreme Court because his deputy was proved to have supplied false documents. So I do not see any reason why anybody will be trying to mix pre-election and post-election issues and then trying to rope in sections 66, 102, 137, and 182(1) with their subparagraphs into what is clearly a pre-election issue. Because the Constitution recognizes the power of the National Assembly to make laws for the good peace, for the peace, good, and orderliness of the Federation. And this piece of legislation is in accordance with item 22 of the schedule, the exclusive list to the Constitution. So, and a similar legislation have been upheld by the Supreme Court. I just cited one now, which is section 31, which was section 31, sub 5 and 6 of the same Electoral Act, which also imposed a disqualifying provision. Yet the Supreme Court upheld it in several decisions, not less than 6 or 8 decisions. So initially, this is my take, but I can go on and on.
Well, we'll get to that part, Mr. Horn. Just let's track back a bit and still analyze this case now, this particular case, especially the process. Because for a lot of people, it came out of the blues. I mean, the National Assembly had barely rejected the president's request to have that section 84(12) deleted from the Electoral Act 2022. Just a few days after, I mean, there was still conversation around what will go on. The Attorney General also saying, well, they have a few options before their table. And then this judgment came just towards the end of last week. So it will seem both of you agree that, well, it doesn't quite contradict the provisions in 66 and others of the Constitution. But let's talk about the process of this particular case. And I'd like to begin with Professor Anambra. So, the plaintiff approached the court, as I mean, it's been reported that the plaintiff approached the court to seek interpretation of the Constitution or that particular provision, as it were. And for a lot of people, it is curious that maybe the National Assembly, INEC, and some other concerned parties are not, parties to that particular suit. So how does interpretation of the Constitution, or in this case, how does it work? Should they have been a party to the case, or it could have just happened without their knowledge and we got to this point where we are right now?
Okay, thank you. It's also been established by a long line of decisions of the Supreme Court that every action against the government, the Attorney General is a necessary party to sue. So if the Attorney General is sued, it is sufficient generally. But in this particular matter that touches on election, I would have thought that the court would have ordered that the INEC, even if they are not a party, should be put on notice, and so that this matter the court can have the benefit of more arguments. Now that the National Assembly also, of course, they have made the law and it is assented to. They don't necessarily have to be a party, but INEC. But having said that, there was sufficient evidence before that court to know that these are Section 66 and all that are talking about a different scenario entirely, as my brother had just said. And even if the court voids that provision, rightly or wrongly, the court couldn't have gone to a point of saying delete, repeal. Repealing of legislation, as a draftsman, I know that it's a legislative act. You know, it's a legislative act. Again, political appointees are not really, they are not public servants as such. I hope you know what, let's even move it a bit out of ordinary arguments alone. And so you can understand why that Section 84.12 shouldn't be tampered with. A governor may appoint 400 special advisors and assistants and all that. And then they become automatic delegates. What will be left of that primary selection? That is what is at play, so that Nigerians can understand what it is. So all you need to do is appoint as many special advisors as other, and before the race starts, a governor's candidate, maybe the president's preferred candidate, is already miles ahead of you. So, and these are the reasons why we don't have much development, because these people are paid from government funds.
But Prof, just on that same issue, my sincere apologies for butting in, but on that same issue, you've tried to help us establish who a political appointee is. But in what section of the Constitution is a political appointee recognized? The definitions in Section 318, I was looking for it.
Okay. Section 318 is very clear that they are not political appointees. And you know the cases of Asogwa and Chukwu and all that. They are there. The court has formally said political appointees are not public servants in the sense of what is being discussed. And they are not guided by public service rules, civil service rules. They don't take civil service exam for promotions and all that, anonymity and all that. Now, the point by and large is that Section 84.12 should be allowed to stand. That's so beneficial to this country. If it stands, we would have made progress in our political work. But if we begin to pull down things that are peculiar to our political experience, that will help us to make the right steps forward, then it is sad. I think that the appellate courts will review this type of interpretation.
Okay, let me go back to Mr. Hon, because I recall when the president sought for the review or the removal of that section, the sections of the Constitution he quoted was, I think, 40 and 42, saying that this would, it contains inhibitions and restrictions referred to under sections 40 and 42 of the 1999 Constitution as amended. That's for 7 political office holders. But the court in its judgment referred specifically to sections 66, sections 107, 137, and 182, which is, quite different. But still going back to the process of this particular case, it's quite curious that, a plaintiff approaches the court to interpret that particular section, and the only other representative we had was a counsel to the federal government, whose position we know is that, this particular section should be removed. So isn't it tilted to one side still? And I'd like to get your views on that as well. How would you describe that particular, angle of this case? That's for Mr. Hon, by the way.
Yes, I was worried because for the first time in the history of my watching, for the first time in the history of my watching post-court proceedings, television shows, both counsel for the plaintiff and the counsel for the attorney general were towing the same line. I was wondering, because you came to court for interpretation and you were expressing satisfaction when the court refused to accede to what you came for. And also, the counsel for the attorney general was also excited. So it gives me some boost impulse, but I said no more. Now, having said that, I do not think that the president's arguments, with due respect to him, to his exalted office, are tenable. Now, why do I say so? A similar situation arose in Kenya, and the Elections Act of 2011 had a similar provision, like Section 84, sub 12 of our Electoral Act. Now, the Attorney General was not pleased. He went to court for interpretation. And the lower court agreed with him and struck down that similar provision. The Public Service Commission of Kenya went to court and reversed that decision. And in fact, the Court of Appeal of Kenya held that it's an abuse of public office for you to stay in power as a political appointee and then still be canvassing for votes. Because, they say, that court also said that decision was handed down in February 2022, around the 7th or 8th of this year, or February this year. So it is a current decision. If a smaller democracy like Kenya can be bold enough to tell the Attorney General that what you are doing is wrong, I wonder why the courts in Nigeria shouldn't do that. Because there is that distinction. Section 318 has defined who a public servant is. And let's also let's interrogate this issue further. If you look at sections 147, Section 147 of the Constitution empowers the president to appoint ministers. And then Section 171 also empowers him to appoint certain political office holders. Mark you, the word there is appoint, not employ. Section 66, sub 1F, and the rest that they're referring to, makes provision for employment, anybody employed in the public service. So how can these two be married? Now, the law is well settled by the Supreme Court and the Court of Appeal of Nigeria, that when a phrase or a word has been defined with the use of the word means, for instance, they say this paper or this television means so. That definition is hard and fast. It does not admit of any other definition. But
ask you, Mr. Hon. Just 1 second, Mr. Hon. Just 1 second. If I can ask you, is there a provision of the law or the Constitution that empowers the judiciary to review law made by the National Assembly?
Very well. Section 1, subsection 1 of the Constitution makes the Constitution supreme, and then section 1, subsection 3 empowers the courts to strike down any provision that is offensive to any part of the Constitution. That is also replicated in section 4, subsection 8 of the same Constitution. But in striking down, you don't just go out striking down each and every legislation.
Okay, in the event, just a minute, in the event that, you know, the judiciary finds such a provision of the law contravening the Constitution, what's the process of reversing it?
No, the process is for somebody to go to court, and then the judiciary will strike it down. But when
the strike down is done, how is it to be effected?
Well, you see, and that is another worry for me, because for the first time, I'm hearing that the learned Attorney General of the Federation says he's going to gazette what has been struck down. With due respect to the Honorable Attorney General of the Federation, this procedure is not correct.
Okay, let's listen. Okay, just 1 second. There is this other opinion that I'd like Professor Anambra to respond to. It is by a fellow SAN such as you, Chief Michael Zekome.
When the National Assembly was making Section 84, subsection 12 in the amended Electoral Act, by saying all political appointees shall not partake, shall not vote or be voted for at congresses or political parties, it was acting ultra vires, because the Constitution in Section 65, 66, 175, 176, 182, 183 has already told us who can contest elections or who is disqualified from contesting elections. So the National Assembly cannot add or subtract. The court has spoken, and it is finished. It is finished. Once the court has spoken, except the people, the defendants in that case, appeal the judgment, and the Court of Appeal sets aside that judgment, and it further goes to the Supreme Court, the final Court of Appeal, and it sets it aside. That judgment remains extant, subsisting, valid, and constitutional.
Your perspective, Professor Anambra.
Yeah, I agree with my brother in certain areas, but largely in some many areas I don't agree. Now, I agree that the court can make pronouncements, which we've canvassed already, Section 6, Section 1 of the Constitution. I hope that many people who argue this issue realize that we are talking about constitution to constitution. Now, the point has been made earlier in this program now. The Section 66, 107, and all that are talking about employees. Section 8412 is talking about political appointees. And employment in the public service carries certain public service character. Now, the court, if decisions like Dada Nade and Asogwan and Chukwu and all that had been cited before that court, perhaps that court would not have come to the same decision it came to. What is being said here is not about, you were alluding to Section 40 and all that. Those are fundamental rights provisions of Chapter 4. They are not even, they are not absolute. Now, to begin to say that the court is right or wrong, it's not what we can do in the media.
Okay.
We are only saying that if you look at the judgment, When was this act signed into law? February 25th. We are not even into March 25th.
Okay.
And
well,
there is so much. There is so much. Just 1 minute.
Okay.
There is so much of, okay, we are going to Gazette. We are going to challenge it in court. We're going to Gazette. The appellate process has not gone through. Before you stop me, let me raise one scenario that is very important.
You will raise that scenario. Just a second, Prof. You will raise that scenario when we return from this break. Please stay with us. Thanks for staying with us. Professor Anambra, you were trying to set a scenario earlier.
Yes, the scenario I'm going to set is, what if a political party now relies on this interpretation, goes for a conference or a convention, and allows political appointees to participate and vote. And after voting, the appellate courts return section 8412. What will happen to the conference, to the convention? What will happen to the process? So I think that as we march through this political process, both the bench and the bar should be wary what role we play, what interpretations are given, because where the court is the last hope of the common man. Like my brother said, a judgment is given in a very landmark case like this. The defense counsel is jubilant that he lost. I don't know how it looks like, but you know that that's not the traditional role of the defendant. The defendant has not even consulted his client for even these celebrations. But what I want to say going forward is that we will look at what happens in the days coming. The National Assembly, if they feel very strongly, can appeal as an interested party. INEC can. These are part of the areas where INEC should show independence. Because some of these decisions now are beginning to affect their preparation for the elections.
But, so, Prof, you know, those issues are endless, certainly, and we'll get into those as we go along. But there's another legal practitioner that's just joined us now, and that is Monday Ubani, who is chairman, NBA Spittle. He joins us via phone. Thanks for joining us this morning, Mr. Ubani. Well, this is an issue that certainly interests you because you have commented on it already, but the arguments are endless. The definition, for instance, of political appointee is not explicit in the Constitution.
And that is correct. And that is correct. And then there is a judicial pronouncement by the Court of Appeal which says that political appointee is not within the definition of a public servant that requires even to resign 30 days to the election. If you remember the case of Shegu Oni and versus Fayemi, the Court of Appeal affirmed the decision of the lower court, excluding political appointees as those who are bound to resign prior to election. And that judicial precedent has not been disturbed by any appellate court up to this point in time. The position is this, Ayo, concerning this present matter. I have argued through my article that went viral that I'm totally in agreement that that particular section is at variance with the provisions of the Constitution. My only problem is the method.
What part of that provision is at variance with what part of the Constitution?
Beautiful. The Constitution, let's even assume that the correct position of the law is that the public servant should resign 30 days before election. Let's assume that is the correct position and that political appointee falls within the definition of a public servant. If the Constitution says you have to resign 30 days to election, will it be right for another law that is clearly inconsistent with that provision now says you have to probably resign several months before
before the election. Is that not an inconsistency in the Constitution? If the Constitution says, this is how many days we have to resign, and then an enactment of the National Assembly now
the provision, Mr. Obani, just 1 second. The provision, just a second, Mr. Obani. The provision in the Constitution talks about public office holders, no, beg your pardon, public servants, not political appointees as stated by this contentious clause in the Electoral Act.
Yes, that is one aspect of the inconsistency I was referring to. Now, the issue of discriminatory law that is meant to discriminate among political office holders. Now, if you remember that section says National Assembly members, legislators, governors will still remain in their office and contest and vote for. But the political appointee that is appointed should resign several months before the election. And the argument of people is that, look, elected officers have tenured appointment. I'm saying that political appointees are appointed by an elected officer. A governor appoints a political officer, a political appointee. And that person happens to be his own candidate he wants to run an office with. And you are now asking that person to be removed from an office when the political appointee, appointer, has not removed him. You are going against the political appointer that is also elected. Remember that he has appointed this individual to run an office with, to help him actualize his political objective. And you are now using a law to drive away this individual, contrary to the express intention of the political appointer. Because he is also elected. Because if the argument is, National Assembly members are elected, and so they have tenure position, one of the political appointer that is also elected, they have now selected this individual to help him actualize his objective. You are not asking him to go leave office before even the appointer, before the time the appointer will ask him to leave office. So I am saying that particular section of the law that says the political appointee must leave an office several months before the election is clearly discriminatory. But allowing the person who is elected to remain in office, vote and be voted for, it is clearly discriminatory. A law that National Assembly cannot enact that is clearly inconsistent with the provisions of the Constitution, which is the ground law.
Well,
that
some would say that you can also...
and then there are several other arguments.
Mr. Bani, if I may come in now... pardon me, just a moment. Just on the point you made...
Several months before the election.
If you can hear me, Mr. Obani...
months, which is what the court in Federal High Court, Maya has actually held.
Okay, just following up on one of the points you made, Mr. Obani, if you can hear me. Some will say that argument can be made for, that provision in Section 66, which also says that no person shall be qualified for election to the Senate House of Reps if he is a person employed in the public service of the Federation of any state. So essentially, it's removing the person from office before, the person fulfills the mandate, as it were, that the person was employed for. And I just want to ask you, practically speaking now, what do you think the Constitution was trying to cure when these provisions in sections 60, 66, 107, 137, 182, 1F were made? What was it trying to cure, saying you must resign 30 days before that election?
When you are in an office, you have some certain privileges and position that is attached to your office. And so I'm sure what the Constitution was trying to cure is to allow a level playing ground for every political aspirant. That the person who is in government or who is a public servant should not take undue advantage of his or her position in order to probably make it advantageous to him and put the other person in disadvantaged position. That is why the Constitution says you must resign.
Isn't that the same thing that Section 8412?
A level playing ground for everyone.
Right. Isn't that the same thing that Section 8412 of the Electoral Act 2022 is trying to cure as well?
No, but if it's asking you now to resign several months, that is the issue. If you look at that decision of the Federal High Court in Oman, it says, let it remain that the public servant will resign 30 days prior to the election. And so if it's 30 days prior to the election, it is correct. I don't have any issue with that. But if you're not saying several months, contrary to the express intention of the appointer has the reason for appointing that individual. You are not asking the person to live several months. And that is contrary to the appointer's intention.
Well, just to be clear, Mr. Obani, that particular act does not say several months.
If going by that particular act, all political appointees who want to contest election in 2023 should have resigned by sometime in March this year. They are all cut off. They are all cut off by the provision of that particular act. If you look at it very well. By now, they ought to have resigned. If you are going to contest the election as a political appointee in 2023, by now you're supposed to have tendered your letter of resignation.
And so, I mean, the dates can differ.
30 days prior to the election.
I think the dates will differ depending on when the party chooses to conduct, the convention and all of that. But specifically, that act does not say several months.
Most of the primaries is going to hold this year, sir. Most of the primaries is going to hold this year, and that will be several months prior to the election of 2023. Election is taking place in February next year, and most of the political parties will hold their primaries this year. And so you are asking the political appointee to leave office several months prior to the election of 2023, sir.
Okay, so let me take this. I just wanted to make it clear that several months is not specifically said in that law, but of course you can interpret it as that. But let me take this to Mr. Hon and get his perspective. So clearly Mr. Albani thinks that this is still in contravention of provisions in the Constitution. And he said, I mean, saying several months as opposed to 30 days is a bit too far. And I wonder, what do you think about this, seeing that a fellow legal practitioner, agrees with the provision?
Well, I totally disagree with him because in the first place, he posited that the provision is discriminatory. But when you confronted him with section 66(1)(f), which says 30 days, the same objective is sought to be achieved, he now began to say something else. But well, I will not go further. What I will say is that the same morality that shouldn't allow somebody who is holding a political office as an appointee, and he's going to contest primaries with people who are not holding political offices, should be applied. It's a two-way traffic issue, because those ones are not holding any political office. Then there should be a level playing ground. He's quoting level playing ground. Is it only for political appointees? So it's not discriminatory either. If you look at section 45 of the Constitution justifies any law that is made for the public good of Nigeria. So, and I also quoted section 4, subsections 1 and 2 of the same Constitution. The National Assembly has power to make law for the goods of the country, the peace and good governance of the country. So now, if they decide to say that for a level playing ground, if you are a political appointee enjoying the perks of office, that alone is discriminatory. But we can't stop it. Then step aside some months, also come and canvass for votes, so that you get public support, not staying there and using your position. These similar arguments were canvassed in the case of Public Service of Kenya against the Attorney General of Kenya, which I referred to. February 7th, the Court of Appeal of Kenya upheld section 43, subsection 5 of the Elections Act of 2011 of Kenya. Now, similar arguments that he advanced, that what of the members of the legislature who are now resigning? They can't resign. A similar provision, section 43, subsection 6 of the Kenyan Law Act, rather, also exempted governors, National Assembly members, and other people from resigning. If we pursue the law that way, then we'll also be saying that that was discriminatory, but the Court of Appeal of Kenya said, no, it's not discriminatory. So what I'm saying is that this law is valid. A law can only be inconsistent with the Constitution if it's mutually exclusive of the Constitution. In fact, in that Kenyan decision, they said that there are some other provisions, just like in the Nigerian Constitution, that says you must resign some days to the election. So the Court of Appeal of Kenya held that that particular provision of the Electoral Act was made to assist those provisions to the Constitution.
Mr. Hon, there will be questions as to the propriety of the Kenyan case or Kenyan Constitution in the case of Nigeria. I understand that you're trying to draw inference, but I mean, we're staying with the laws of Nigeria, so perhaps that should be the focus here, except we say that maybe we need to copy some of those provisions.
I have never left the laws of Nigeria.
All right.
My learned brother, Professor Anambra, has cited at least three Supreme Court of Appeal decisions
that say political appointees are not public servants. That should have answered this issue. He graciously said that if those authorities have been referred to the Federal High Court judge, perhaps a different decision would have been reached under the doctrines of judicial precedence and stare decisis.
Right.
Perhaps they were not raised, but if they were raised and sidetracked, then it's unfortunate, but I do not believe they would have been raised. Now, having said that, because time is running out, I want to address an issue that Michael Zekomo, my learned brother of the Anambra, raised, the doctrine of covering the field. Because time is running out, and Nigerians need to know, covering the field is not all-encompassing. In fact, covering the field is an 1842, it has an 1842 origin in Australia. It has been applied severally in Nigerian courts, including the Supreme Court of Nigeria. In 2013, it has two ends. One is that where the Constitution has covered a particular area, no other legislation should cover. Another aspect of it is that once a federal act, that is an act of the National Assembly, has covered a particular area, no state law should cover. So, but the principles are the same. In 2013, there was this decision of the Supreme Court appealed by the Attorney General of the Federation against the Attorney General of Lagos. Lagos State had enacted 3 laws to regulate hotels. And the Attorney General of the Federation challenged that provision, those provisions, and say that tourism under item 20 of the exclusive list belongs to the federal government. And therefore, the doctrine of covering the field excludes Lagos, or excluded Lagos, from making provisions for hotels. See how close hotels, hotel business and tourism are. The Supreme Court said no. The item 20 you are referring to did not cover the field, did not cover hotels. So no matter how close public servants are to political appointees in terms of definition, which I disagree, I don't concede, the two cannot be married together. I also am enamored.
Let me ask you, sir. Let me quickly ask you, sir. So it would seem that, Mr. Hon, if you can hear me, it would seem that you agree with Section 8412 as currently is in the Electoral Act. Well, we do not know if it's been deleted already. But I want to ask you, in the event that public officers have to, political appointees have to resign to be able to participate in elections or conventions, what should happen to their seats when they go? Will the political appointer need to appoint people again who will go through another process for a few months just before an election or an electoral cycle? Wouldn't that be disadvantageous on the long run to a nation?
But you see, thank you for that question. You know, my sister, people change their cabinets 3 months to elections, or 3 months to when they're going. Nobody queries that. And that even emphasizes what we're saying here. Political appointees are hired and fired at the pleasure of the appointers. You can appoint a minister today, fire him tomorrow. This is different from a public servant, where we have laid down procedures for relinquishing them of their employment. So political appointment.
The question is that to the advantage of a country on the long run? That's the question I'm asking. I mean, given where we currently are, we know. Please go ahead, sir.
You see, yes. You see, we are just bringing. Well, with due respect, madam, I can answer yes or no. By the way, nobody has exclusive right to enjoy political office. You can be appointed. If you are nursing ambition to go to the next level, you vacate for another person. The other person is also a Nigerian. So everybody must enjoy the advantage or the privilege. You can't eat your cake and have it. And by the way, as I said, the appointing powers have also dismissal powers. So whether or not it's healthy, it's no more a legal issue. It's a moral question. As far as the law is concerned, you can appoint and fire, and if you can appoint and fire, the same person should not sit on that seat and canvass for votes, because he's eating his cake and having it to the disadvantage of other Nigerians. It's as simple as ABC, with due respect.
Let me ask Professor Anambra what he makes, I mean, of that particular scenario, and whether or not he agrees that the Attorney General should be deleting. I mean, I know that people have also taken offense at the the outcome of the judgment. Some people have said that they've never heard it before, that an Attorney General has been asked to delete sections of any law.
Yes,
have you heard that before?
Yeah, I speak clearly as a draftsman, a trained draftsman. Repealing the enactment of a piece of legislation is a legislative act. It's not a judicial act. So, as a legislative act, it's only the legislator that can repeal and reenact. The court can interpret and pronounce. The court ought to have stopped at pronouncing validity or invalidity of the act, and the other legislative and administrative acts takes place. So the issue of this is not a blanket provision in the Section 8412. It only says if you want to participate in the primaries, to stand and be voted for or to vote, resign. It doesn't say all political appointees should resign. It's a decision you choose, a choice you make. It's not discriminatory. What is rather discriminatory is what we have found ourselves in. How many Nigerians will say that what we have today as political culture is correct? Are we going to endorse what we have? Or must we make progress? Why do we blame the National Assembly that they are not making good laws for the country, when they will make good laws and we will strike those laws down? Where are we headed to? The objections to Section 8412, are they born out of public interest? Are they born out of patriotism? Where is the objection coming from? That a law says, if you are a political appointee, which has been severally, in fact, a colleague cited Oni and Fayemi here. Oni and Fayemi is very clear. Oni and Fayemi doesn't even support the argument being put in favor of striking that 8412. He rather supports 8412. You know? So also is PDP, the PDP and INEC. So a minister,
Prof,
for example.
let me quickly pose some of the questions you have raised, Prof. Let me quickly pose it to Mr. Obani. I do not know if he's still with us. Mr. Obani, if you can hear, if you're still following the conversation, would you like to respond to some of the questions raised by Professor Anambra, in whose interest is 8412 if it's deleted?
Well, if you can hear that, Mr. Obani is asking, in whose interest is a Section 8412 to be deleted, in your opinion?
Yes, I must confess that I didn't hear a bit of the word of the learner's sake because of the fact that I'm joining through telephone, so I didn't understand what he has just said. But the question you asked, in whose interest is Section 84? And that, I think, is in the interest of the country, generally, by the assumption of those who have enacted that particular law. When the president was raising a objection to the constitutionality of that section, some of us did not see the wisdom at the point he was raising it, because we felt that the president himself did not raise that issue in the first time. There was a particular issue he raised with the issue of primaries, and that was corrected. So why didn't he raise this particular issue? So all of us were against the president, asked him to go ahead and sign the Electoral Act because of some of the innovative provision in that act. And so we didn't look at the wisdom at that point in time. But after the signature, people begin to look at the provision of that section and consider it whether it is clearly a fair section. It's not a popular opinion, necessarily, because some of the governors have abused the issue of political appointees parties using it to
Mr.
their own
Obani,
political
we're winding down now, but I just wanted to quickly put this through to you, if you can do in 30 seconds. It's a double-edged one, so maybe short answer. First, who's going to appeal this? Because the parties to the case seem to be okay with this particular judgment. And the second edge is, can the APC go ahead with its convention with a deleted Section 8412?
Yes, they can. For now, I don't know any interested party. I think the National Assembly, is an interested party. I'm surprised they were not joining as a party. INEC should be a necessary party in this particular suit. So all of them at this juncture can come in, in the Court of Appeal as an interested party. They can appeal. And that's why I was surprised when the Attorney General, Honorable Attorney General, was saying that it's not going to be an appeal. He cannot conclude that because interested parties have a right under the law to appeal against that particular judgment. INEC and National Assembly, or any NGO, any NGO can come in as an interested party in this particular case in order to appeal against it. Now, it does not stop APC from going ahead with their primary, because for now, the position of the law is that that particular section is deleted. It's no longer in existence until it is turned in a Court of Appeal decision.
Okay.
The present position of the law is that that section now does not exist.
All right, Mr. Obani. Well, yes, thank you, gentlemen. I'm just wondering what's going to happen in Kaduna State now, where that memo already went out to political appointees. But for now, Sebastian Horn, Senior Advocate of Nigeria, Professor Paul Anambra, Senior Advocate of Nigeria, and Monde Ubani, former second Vice President of the NBA. Gentlemen, thank you so much for your perspectives this morning on this issue.
Thank you.
Welcome. Thank you.
Okay, yeah. So we're back right after now with another topic. It's on development. Please stay with us.
This is the first time the quadrangle of the Anambra State Government House is being used as venue for the swearing-in of a governor-elect, as select guests make their way here to witness a change of guard in Anambra State. The governor-elect, Professor Charles Soludo, in company of his wife and family, arrived at the arena, whilst others, including the Deputy Governor-elect, Dr. Onyeka Bezim, political and traditional leaders, amongst others, had made earlier entrances. On his final official moment as governor, Mr. Willie Obiano makes his entry, inspects the guard mounted in his honor, marking the commencement of proceedings. And without much ado, the Chief Judge of Anambra State administers the oath of office on the Deputy Governor-elect. Next, the Governor-elect, Professor Charles Soludo, is sworn in.
I will preserve, protect, and defend the Constitution of the Federal Republic of Nigeria. And defend the Constitution of the Federal Republic of Nigeria. So help me God. So help me God.
Now, as the Executive Governor of Anambra State, Professor Charles Soludo emphasizes his vision to make Anambra a prosperous land.
Dr. Ibezim and I will work very hard every day to make you proud. We will seek active collaboration and cooperation with the federal government, our neighboring and other states, as well as the international community, to provide our state truly people-centered governance. We will consolidate the progress made by our predecessors to continue Anambra's upward trajectory.
Some of the guests expressed their optimism about the new administration.
Governance is about caring for the poor. It's about ensuring that people are pulled out of poverty. And look at his promises today. He consistently maintained that he's going to work for the people. He's going to secure the states. We say this state is the light of the nation. That's what I christened it. And that's what we want it to be.
According to the new governor's schedule, he is to work for 8 hours immediately after the swearing-in ceremony. And true to his words, he retires to his office in the government house, where a 4-year journey to reposition the state begins.
Well, Dozie Diopala-Obieri joins us now. He's an economist, a lawyer, and principal partner, Hamilton and Associates. Good morning and welcome to Sunrise Daily this morning.
Good morning, Mokwe. How are you?
Well, thank you. Well, what an inauguration it was. I mean, it was meant to be low-key. Somehow things got a bit out of hand, but, you know, eventually came back under control. And the governor has started already. He started work on the very first day he resumed. Now, he has also made a few vows to the people of Anambra State, and I'm sure that expectations are high. But for the people of Anambra and for the governor, what do you think could be some of the quick wins that he could immediately achieve to set the tone for what he intends to do in Anambra?
Mope, thank you very much. One of the things the governor has always said right from the beginning in terms of quick wins, where, for example, the visit to Okpoko, which he did on, I believe it's on Friday, his second day in office. He started right off with that in terms of visiting the slum and engaging with the people and doing some cleanup over there. But I think the more important, another important aspect is looking at the revenue of the state and closing what he calls the revenue windows, disparate revenue windows. Current IGR in Anambra State is about 30 billion as of last year, according to Anambra State records. And he issued an executive order in order to close, setting up those windows and reconciling that so that much of the IGR is coming directly to the states and not necessarily being diverted. So I think in terms of quick wins, that will be one area that he'll be looking at, or he started to look at in order to have some impact, generally speaking. The other thing is they look at some markets, looking at bills that could be presented to the State House of Assembly, presenting bills for the Anambra Market Regulatory Authority, as well as the Anambra State Development Corporation. A number of these are in trying to realign the governance structure to do with the markets and in other areas of the state, again, to improve governance, generally speaking, and also to start to realign what the governor will see as critical areas for improving the economic well-being of the state.
Well, let's talk about security, because I know that one of the things that he has to, first of all do is ensure that Anambra is secure before, we can talk about economic gains. It's a good thing that he's already trying to see how he can secure the bag for Anambra. But in his speech, he paid tribute to 3 officers who lost their lives when he decided to declare his intention to run, which, immediately sets the tone about some of the security circumstance prevailing, even the elections in Anambra, and what has become of the security situation. There's been some pull and push in terms of how security is now perceived in Anambra, separatist tendencies. How do you think he could go about navigating that, pacifying those who need to be pacified, separating those who have gone rogue from those who are genuine agitators, and generally ensuring that there's an atmosphere for economic development in the state?
Indeed, you hit a high point, because security indeed is the precursor to any progress that will take place in the state. And I think he devotes almost 10% of his inaugural speech on security. First, calling on, first of all, recognizing the March 7th statement by the joint statement by the bishops, archbishops, and traditional rulers in the state in calling for a dialogue between both that group, the federal government, and the state governors in the Southeast in order to address this critical problem. I think that law and order is certainly one area that he would like to, in fact, he does address that directly in his inaugural speech. And like I said, devotes almost 10% of the inaugural speech on that. The other is that call for dialogue. There's a need to restore productive days, particularly in Anambra State, but across the Southeast. There's a need to restore productive days. And he does call for a dialogue between the disparate parties, recognizing that, the agitation is real, but as he calls it, there's no challenge that cannot be discussed. You know, if all the parties come to the table and those challenges or whatever the agitation is can be addressed at that level, and there's no need to take up arms, or at least go ahead.
Do you think he's secured the confidence of the agitators well enough to be able to mediate sort of in the things that they agitate for?
I think, generally speaking, there is a groundswell of support for this new governor. There is a sort of a hope. I mean, it gives credence to Anambra being the light of the nation, so to speak. So he does give credence. He has that reputation. He comes in new to this. And in fact, I mean, I was reading press reports 2 days ago, thereabouts, where I suppose certain elements of IPOB, for example, and he does call everyone by name, certain elements of IPOB did say, look, if this new governor is going to engage and engage appropriately, we're ready to talk. So I think we're already starting to see those signals. And I think that's critical and that's important. In no environment where there's no peace and security can progress occur. And I think he recognizes that and addresses it head on in his inaugural speech. So that's going to be important. And I think he does have the credibility to address it.
In the first 100 days, what should we be looking to see in Anambra? I mean, as someone who is also going to be making demands of the government of Anambra State, what do you hope that the governor would have achieved in his first 100 days to be able to, not just for the people of Anambra, but to be able to set a different tone, to say this is how we envisage government to look like? I mean, he's done a few things already, talking about how he's going to be buying local. He's made that statement by saying he's only going to be driving in innocent motors, and he made that statement at his inauguration, etc., etc. So we're already seeing certain things. But apart from that, I mean, to really say that this is a different trajectory, what do you hope to see in the first 100 days in office?
So I think it's not just making the statement, he's already living it. I mean, I think if you look at his dressing, the Appointee clothing that he's been promoting, you saw at his inauguration, he drove to and away from the swearing in an innocent vehicle. So that aspect of it, he's starting to live it already. He also, like I mentioned earlier in the segment, he did do a visit to Okpoko, as well as Onitsha and some other environs where he had promised to visit on a couple of days. I think on Sunday, that was yesterday, he did a round of prison visits, again, sort of addressing the justice angle in the spirit of Onyang and Awanne, which is, do not leave your brethren behind. There are people who have been in prisons for probably up to 15 years from the segment I watched, where they've been on trial for 15 years without complete adjudication. But that aside, what do we expect to see from the new governor? I did also talk about, apart from the security issue which we've addressed, improving the investment climate, improving the ease of doing business in Anambra State is certainly one. And there have been conversations around what some would call revenue agents. Some will call them touts, but revenue agents who are at different points in the state doing collections in quotes on behalf of the state, now trying to move that to a technology platform whereby that can be centralized in order to reconcile and also improve collection for the state. The other is some of the quick wins in terms of environmental, taking care of the environmental aspect of in the states in terms of waste management. If you visit certain segments of Anambra State, there are a lot of waste on the streets. So trying to address that, doing some cleanup that you could actually see physically, because the quote, health is wealth, is very important. So doing a cleanup and addressing the root causes of why that garbage, for example, why the waste on the street is piling up. Other aspects are more long-term, so dealing with the State House of Assembly, for example, in terms of interacting with the State House of Assembly for bills that would help to address some of the other ills he wants to address. What do I mean by that? The road maintenance agencies. When you look at a city like Onitsha, with some of the gridlock, and even in Awka, the capital city, trying to improve both the roads and access roads in order to drive economic activity within the states and the economic centers and economic axis of the state, improving both the roads and access to both markets and back and forth, as well as trying to ensure that a lot of what needs to be done gets done in that aspect of things.
Okay, I know that you already spoke about him already receiving a groundswell of support, but this singular move, which we've spoken of, about trying to, secure the bag and ensure that, internal.
The visit to Okpoko, which he did on, I believe it's on Friday, his second day in office, started right off with that in terms of visiting the slum and engaging with the people and doing some cleanup over there. But I think the more important, another important aspect is looking at the revenue of the state and closing what he calls the revenue windows, disparate revenue windows. Current IGR in Anambra State is about 30 billion as of last year, according to Anambra State records. And he issued an executive order in order to close, setting up those windows and reconciling that so that much of the IGR is coming directly to the states and not necessarily being diverted. So I think in terms of quick wins, that will be one area that he'll be looking at, or he started to look at in order to have some impact, generally speaking. The other thing is they look at some markets, looking at bills that could be presented to the State House of Assembly, presenting bills for the Anambra Market Regulatory Authority, as well as the Anambra State Development Corporation. A number of these are in trying to realign the governance structure to do with the markets and in other areas of the state, again, to improve governance, generally speaking, and also to start to realign what the governor will see as critical areas for improving the economic well-being of the state.
Well, let's talk about security, because I know that one of the things that he has to, first of all do is ensure that Anambra is secure before, we can talk about economic gains. It's a good thing that he's already trying to see how he can secure the bag for Anambra. But in his speech, he paid tribute to 3 officers who lost their lives when he decided to declare his intention to run, which, immediately sets the tone about some of the security circumstance prevailing, even the elections in Anambra, and what has become of the security situation. There's been some pull and push in terms of how security is now perceived in Anambra, separatist tendencies. How do you think he could go about navigating that, pacifying those who need to be pacified, separating those who have gone rogue from those who are genuine agitators, and generally ensuring that there's an atmosphere for economic development in the state?
Indeed, you hit a high point, because security indeed is the precursor to any progress that will take place in the state. And I think he devotes almost 10% of his inaugural speech on security. First, calling on, first of all, recognizing the March 7th statement by the joint statement by the bishops, archbishops, and traditional rulers in the state in calling for a dialogue between both that group, the federal government, and the state governors in the Southeast in order to address this critical problem. I think that law and order is certainly one area that he would like to, in fact, he does address that directly in his inaugural speech. And like I said, devotes almost 10% of the inaugural speech on that. The other is that call for dialogue. There's a need to restore productive days, particularly in Anambra State, but across the Southeast. There's a need to restore productive days. And he does call for a dialogue between the disparate parties, recognizing that, the agitation is real, but as he calls it, there's no challenge that cannot be discussed. If all the parties come to the table and those challenges or whatever the agitation is can be addressed at that level, and there's no need to take up arms, or at least go ahead.
Do you think he's secured the confidence of the agitators well enough to be able to mediate sort of in the things that they agitate for?
I think, generally speaking, there is a groundswell of support for this new governor. There is a sort of a hope. I mean, it gives credence to Anambra being the light of the nation, so to speak. So he does give credence. He has that reputation. He comes in new to this. And in fact, I mean, I was reading press reports 2 days ago, thereabouts, where I suppose certain elements of IPOB, for example, and he does call everyone by name, certain elements of IPOB did say, look, if this new governor is going to engage and engage appropriately, we're ready to talk. So I think we're already starting to see those signals. And I think that's critical and that's important. In no environment where there's no peace and security can progress occur. And I think he recognizes that and addresses it head on in his inaugural speech. So that's going to be important. And I think he does have the credibility to address it.
In the first 100 days, what should we be looking to see in Anambra? I mean, as someone who is also going to be making demands of the government of Anambra State, what do you hope that the governor would have achieved in his first 100 days to be able to, not just for the people of Anambra, but to be able to set a different tone, to say this is how we envisage government to look like? I mean, he's done a few things already, talking about how he's going to be buying local. He's made that statement by saying he's only going to be driving in innocent motors, and he made that statement at his inauguration, etc., etc. So we're already seeing certain things. But apart from that, I mean, to really say that this is a different trajectory, what do you hope to see in the first 100 days in office?
So I think it's not just making the statement, he's already living it. I mean, I think if you look at his dressing, the Appointee clothing that he's been promoting, you saw at his inauguration, he drove to and away from the swearing in an innocent vehicle. So that aspect of it, he's starting to live it already. He also, like I mentioned earlier in the segment, he did do a visit to Okpoko, as well as Onitsha and some other environs where he had promised to visit in a couple of days. I think on Sunday, that was yesterday, he did a round of prison visits, again, sort of addressing the justice angle in the spirit of Onyang and Awanne, which is, do not leave your brethren behind. There are people who have been in prisons for probably up to 15 years from the segment I watched, where they've been on trial for 15 years without complete adjudication. But that aside, what do we expect to see from the new governor? I did also talk about, apart from the security issue which we've addressed, improving the investment climate, improving the ease of doing business in Anambra State is certainly one. And there have been conversations around what some would call revenue agents. Some will call them touts, but revenue agents who are at different points in the state doing collections in quotes on behalf of the state, now trying to move that to a technology platform whereby that can be centralized in order to reconcile and also improve collection for the state. The other is some of the quick wins in terms of environmental, taking care of the environmental aspect of in the states in terms of waste management. If you visit certain segments of Anambra State, there are a lot of waste on the streets. So trying to address that, doing some cleanup that you could actually see physically, because the quote, health is wealth, is very important. So doing a cleanup and addressing the root causes of why that garbage, for example, why the waste on the street is piling up. Other aspects are more long-term, so dealing with the State House of Assembly, for example, in terms of interacting with the State House of Assembly for bills that would help to address some of the other ills he wants to address. What do I mean by that? The road maintenance agencies. When you look at a city like Onitsha, with some of the gridlock, and even in Awka, the capital city, trying to improve both the roads and access roads in order to drive economic activity within the states and the economic centers and economic axis of the state, improving both the roads and access to both markets and back and forth, as well as trying to ensure that a lot of what needs to be done gets done in that aspect of things.
Okay, I know that you already spoke about him already receiving a groundswell of support. But this singular move, which we've spoken of, about trying to, secure the bag and ensure that, internal revenue generation also, or internal revenue generation goes up and, ensuring that it comes directly to the states without it being diverted. Do you think that it could have any repercussion? Because some people will say that, when you take bread away from the boys, the chances are high that what you could get is, rather than have security, it could, now have something else that you did not intend. Do you think that he's prepared for the consequence of that particular decision?
Not only is he prepared for that, it has been well thought through. Under the Human Capital Development framework, there is a recognition that, yes, in quotes, some of the revenue collectors are job for the boys, so to speak. And there's a recognition that if you're going to take that away from them, there needs to be an alternative that is provided. And there are avenues around that, or that there's a thought around that, which is trying to find alternative or secure alternative, both in investing in their future, retraining as part of that move in terms of the alternative. Certainly, he recognizes there will be pushback, and there's no doubt that there will be some, but it's also appealing. I mean, there's also recognition that the collection agents or revenue agents, as we want to describe them, have all the people behind them. It's also appealing to those interests, because at the end of the day, the revenues being collected that should be coming to the state is to improve the welfare of the state for us all. And in that way, as an economist, I like to think about it as expanding the pie, which will benefit most people and a lot more people than just a few. And that's the drive. But no doubt there'll be pushback, but it's working through that pushback, both in dialoguing and in also using constitutional mandate to ensure that the right things are done over time. And I mean, in doing that, one of the things he has promised is, publishing state accounts, for example, improving transparency and sharing with the state and its people what exactly he plans to do. And in doing so, then calls upon you to call him to account, in terms of, this is the revenue we've brought into the state, and this is what we've done with it. And, the governor can be challenged down the line with his accomplishments and achievements at that point.
Let me come in now. Correct me if I'm wrong, but you're part of that, is it 80-member or 150-member transition committee, right? Of course. So it's been said largely that when, governors or presidents or what have you take office, they usually have a period where they try to acclimatize and all of that. And I'd just like to get a behind-the-scenes view of what's going on, especially handshake between this administration and the previous administration, how well this acclimatization process is going. Because some say it might take up to 8 months or a year to really get, feet on the ground before you start moving. But in this case, how is it going?
First of all, the transition process certainly was, for lack of a better word, a cooperation between the old administration and the Soludo administration. So we worked well together. In terms of even developing the transition committee report, it was very important to understand, unlike in different situations or in previous situations where you either have contentious handovers or you have one party handing over to a different party, and there's not that view of where things are at the moment in order to plan. I think in this instance, The first thing is to recognize that the governor had a vision coming in. I mean, he's been in government as central bank governor previously. He's made an attempt to run for office in a previous election cycle. And so he's had time to not only observe the state in quotes from afar and near, but he's also had time to develop his vision for the state. And even just any regular citizen who from Anambra state or from any state for that matter, when you're in your state and you're looking at things, sometimes in your head you say, if I was governor, this is what I would do, right? But it's also important to have that internal view as to what things are the reality on the ground, as some would say. And so the transition process was a cooperation between the administration and that, led by the then Secretary to the State Government, who is now being appointed again as Secretary to the State Government. So you could see that as continuity. That institutional knowledge is there, and building on that is what's going to happen. So in terms of having the reality on the ground, we have that, talking to the different commissioners and agency heads as part of the transition committee. But like I said, with the new state Secretary to the State Government, who's been reappointed, so to speak, there's that, that continuity is there, and he does have that institutional knowledge and also bearing in terms of the reality of where the state is in terms of, whether it's revenue, security, the civil service, and the like.
Well, another inheritance of the new administration is the 50-year development plan of Anambra State, which, of course, is it comes after the 2014 to 2018 development plan. My contention here, sir, is the buy-in of the people. First of all, if you can, maybe cast your mind back for a little bit, how well would you say that the previous development plan performed, and the buy-in of the people for this 50-year development plan for the state? In your opinion, where is the handshake? Because sometimes we think this is what the people need without necessarily consulting them.
So the assumption that they weren't consulted, I would be remiss to say, first of all, I'm not familiar with the extent of the consultation process. But I do know that, first, I think when you talk about the handshake, the current governor led that team in terms of developing that 50-year plan. So when it comes to the handshake aspect of it and familiarity with that program and what it should entail, he's very familiar having led that process, working with the previous governor. Now, in terms of the consultations and down to the level of the people, you have to understand that in Anambra State, generally speaking, the governance process, both at the village, town levels and at the community levels, that tends to wind its way upwards, up onto the state government. The governor had mentioned, for example, the holding of, looking forward to the holding of local government elections, recognizing the part that local governments play in development in the state, general development in the state. So I like to think that while it might not necessarily be individual consultations, but the different groups within the state, like I said, president generals with their town unions and the like, because the town unions are drivers of progress and development in the different towns in Anambra State, as well as across the southeast.
And I find quite interesting.
Consultations at that level, I could equate consultations at that level to generalized consultations with state people from the state.
Okay, so we're winding down now. And one other thing I find quite interesting is the progressive philosophy that the governor is bringing in. On his inauguration, there wasn't any elaborate, activity of sort, and there will be questions as to how that will sit with the people who are sort of used to that kind of thing, and some have advised, yes, keep your heads in the cloud, but your feet on the ground. But on a final note, I would like to ask you this. What will be the main focus of this government regarding Anambra's comparative advantage? I know that states have their strengths and what they would like to focus on. So perhaps as some sort of measurement over 100 days, what would you say that this government will focus on as the area of comparative advantage in this period?
Wow, that's an interesting question that almost begs for another 30 minutes. But I think, first of all, making Anambra State a very livable, prosperous homeland for, of opportunities and jobs for our youth, generally speaking. And Governor has talked a lot about, if you look at the footprint of Anambra citizens across the country, you would recognize, both in terms of the entrepreneurial zeal, in terms of technology, just across the board. And it's now trying to bring that footprint. If I may even use this is a term I'm coining on the spot, but you can keep your left leg elsewhere, but bring your right leg back to Anambra State. So improving Anambra's investment outlook, attracting investments to Anambra State, that would help to drive economic development across the board, so that those in the vulnerable groups, women, children, and just generally speaking, can find Anambra State to be a place that they want to be. And the idea that a child who's born in Anambra State doesn't necessarily have to, back in the days is everybody goes to Lagos or Onitsha, which is the nearest Anambra city. But a child that grows up in Anambra today should be able to, at least over the next couple of years that the governor leads the state, a child that is born in Anambra State will see no reason to have to leave Anambra State in order to grow and make an impact in this world. And I think that's the key aspect. And it's going to involve a lot of work. He recognizes that, but there's no moving or shying away from that. And I know lots of work ahead. There's a phrase we use during the transition committee work, which is Orodi, Managadi, which is there's a lot of work, but there are battles ahead in order to get through to that. And I do believe that the governor has what it takes, as well as the people around him, to drive this process through. And I think if once both Anambra citizens, residents, and anyone that does business in Anambra starts to see the signal, and you're already seeing the signaling, whether it's the dressing, the visits, some of the drivers that will take place over the next couple of days, over the next couple of months. And, given that this is a seamless transition, I do believe that we'll make that progress. And in another couple of, well, let me not say months, but another couple of years, we'll start to see the Anambra template being copied, just the same way as Lagos is being looked at for some good examples to emulate.
It's a fine place to leave it. We have to thank you so much for your contributions this morning. Dozie Diokwa Laubiri is an economist, a lawyer, and principal partner at Hamilton and Associates. Thank you so much for coming on Sunrise Daily. Thank you, Mokwe. Have a good day. Good. Have a good day too. We have a few feedback tweets. Pastor Law Alpha Cross says the clause has already been captured in the Constitution, so allowing it to remain in the Electoral Act would amount to a constitutional accident, which ultimately would introduce some traffic. That's with regards to our discussion on Section 8412 of the Electoral Act. So that's the contribution of Pastor Law Alpha Cross.
Constitutional accident? Hear that for the first time.
And then some traffic.
Festus Akimboye on the same issue. The National Assembly is right to insert Section 84, subsection 12, to create a level playing field in selection of candidates for political office holders, since PMB declined to give consent to the original bill that recommended primary elections for the selection of candidates for elected offices.
Well, take a look at Daily Content's tweet saying, "It is not that we believe the law to be just. The law is always subjective. We just want a clear interpretation for the average Nigerian. Is the removal of Section 8412 an action for the politicians, highest bidder, or the masses?" Big question there.
Well, I understand what he's saying. Now, sometimes this sounds like you're in a law class and you just want it to be broken down. Bakare Abiola Muiz talks about this. He says, isn't the Constitution the foundation of law? Shouldn't the law profession have a common standing on these contentious issues rather than have their SANs at each other's throats? It seems like the law profession enjoy this, I think he means lacuna, and is taking full advantage. Well, you know what? Having one case and 100 lawyers having different points on that one case is just how it is. The lawyers are us, we've been told, and that's where the courts come in to interpret clearly and correctly for the well-being of all of us. We have to thank you very much for watching and contributing this morning. I'm Maokbe Yusuf.
Well, as Maokbe said when we started off, let's make it our best week yet. I'm Kayode Okikelu.
Again, God bless Nigeria. I'm Ayo Makini. Have a wonderful day.